Good afternoon, everyone. I am pleased to be back here, joined by Professor Stephen D. Schwinn of the UIC John Marshall School of Law. Professor Schwinn, thank you for joining us.
Kathy, it's so good to be back with you.
Always a pleasure. So today I was hoping we could dig in a little bit to one of the cases that was argued at the end of February before the Supreme Court, Lange versus California.
Yeah, absolutely. So this is a Fourth Amendment case. It's a really interesting one where the fact situation is interesting, where you have a driver, Arthur Lange, who is playing his music in his car really loudly, beeps his horn a couple of times, and gets the attention of a police officer, Aaron Weichert. So Aaron Weichert follows in his patrol car, follows Lange back toward his home into his neighborhood, but Weichert doesn't turn on his lights and he doesn't beep his horn. He doesn't indicate that he's following him, and Lange apparently has no idea that he is. So they pull into Lange's neighborhood and they start pulling up close to Lange's house. And only when they actually get really, really close to Lange's house does Weichert turn on his overhead lights, indicating that he's a police officer trying to pull over Lange. Well, Lange says he doesn't even notice. He pulls right into his driveway and right into his garage. Weichert follows him into the driveway, and as Lange is putting down the garage, Weichert then gets out of his car, puts his foot under the garage to trigger the sensor. Garage door goes back up. Weichert goes into the garage and says he detects the smell of alcohol on Lange's breath. And later tests revealed that Lange had something like 3 times the legal limit of alcohol in his blood. But Lange moved to suppress that evidence on the theory that Weichert didn't come into his house, into his garage, with a warrant, and that the Fourth Amendment required a warrant. And because he didn't come into the house without a warrant, the exclusionary rule means that any evidence that Weichert found as a result of that search has to be excluded. The case went up through the California courts. The California courts ruled against Lange, and then the Supreme Court took it up this week. Really kind of interesting question about the Fourth Amendment. As a general matter, a home search requires a warrant, but there are important exceptions to that. So, for example, a person can consent to a home search, or exigent circumstances can justify a home search. And exigent circumstances would be things like an officer's trying to get a fleeing suspect and make sure that the suspect doesn't escape, or preserve evidence, or preserve public safety, or something like that, that truly is an emergency. One of these exigent circumstances is a pursuit of a person, in particular, what's called a hot pursuit of a suspect. And some courts have said that there's a categorical exception to the warrant requirement when an officer is engaged in a hot pursuit of a suspect who is suspected of committing a felony. This case tests whether that categorical exception applies to a person who's suspected of committing a mere misdemeanor. Now you might say, well, what was the misdemeanor in this case? The misdemeanor was when the officer turned on his lights and Lange failed to obey. So what the officer is saying is basically the failure to obey when I turned on my lights at that last minute before Lange pulled into his garage was the misdemeanor that then triggered this entire case.
Steve, I'm wondering if you can talk a little bit about this felony versus misdemeanor standard and why this is important. I think it's so interesting that, as you mentioned, the hot pursuit exception to the exigent circumstance exception to the warrant requirement has always been in hot pursuit of someone that the officer has probable cause to believe has engaged in a felony. So this is, as you said, a misdemeanor. And what's the distinction there? Why does this exist? And what do you think the court might do with that?
Yeah, it's a great question. And it came up in oral argument all over the place this week, this distinction between felony and misdemeanor. Now, what the court has said is we're going to give an exception to the warrant requirement for a hot pursuit of somebody who's thought to have committed a felony, because the seriousness of the crime suggests that when an officer is in such a hot pursuit, there really are exigent circumstances that justify doing away with the warrant requirement, or at least that's what the courts have said. Misdemeanors are a little bit different, though. As a general matter, they're less serious crimes, but over time, that really has changed, and the waters are pretty muddied here. So, as the Chief Justice pointed out at oral arguments this week, for example, some things that are thought to be a misdemeanor when a person commits them once turn into a felony when the person commits them 3 times. And as other justices pointed out at oral argument, some states treat misdemeanors like other states treat felonies, and there's a real big gray area. The distinction really is ambiguous today. That's one of the big problems in the case.
Yeah, I found at oral argument one of the really interesting sort of trip down that road was from Justice Kagan and talking about this notion of violence being an aspect of a felony, at least at the time of the founding, and sort of how we think of felonies, particularly in justification of the hot pursuit exception. And the example that she gave, which I thought was for me was really compelling, was in many states, domestic violence crimes are not always felonies, but white collar crimes, which are usually financial crimes, which certainly don't have a lot of violence associated with them, are felonies. And I thought it was really interesting during this oral argument to see how the justices were sort of going at this fundamental aspect of our criminal law system and really seeing maybe some of the problems with it, or some of the, as you mentioned, the gray areas with it.
Yeah, I think that's exactly right. And it goes to this, if we sort of tie this back to the idea of exigent circumstances justifying an exception to the warrant requirement for a home search, the court treats exigent circumstances on a case-by-case basis, right? It doesn't really have categorical rules for exigent circumstances, except that some courts have treated this hot pursuit of a felon as an exigent circumstance categorically. And so there's a little bit of a mismatch between the way some of the courts have treated this as a categorical matter and the case-by-case approach. And I guess what I'm hearing you say, Kathy, is that the confusion really between what's a misdemeanor and a felony across states today it kind of feeds into that, right? We would expect maybe what we ought to do instead of categorizing things as a felony or a misdemeanor is look at the totality of the circumstances in any given case and determine whether there are exigent circumstances to do away with the warrant requirement.
Which I think is such an interesting conclusion to come to in this, right? Because so often certain justices on this current Supreme Court like Brightline rules and like clear tests that make it obvious for an officer in the field to apply or for a reviewing court to be able to apply. And this idea of maybe going back to a case by case for this exigent circumstance exception, I think is a really interesting sort of step back in some of where the court tends to go with its criminal jurisprudence.
Yeah, well, that's a really interesting point. Yeah, and so you can think about the natural extent of an extended categorical exception here, and why it might both give a bright line, but also might give us some pause, right? Think about the facts of this case. If there were a categorical exception for misdemeanors, what this means essentially is that the officer can turn on their lights literally in front of the person's house. And if the person misses it and nevertheless goes into their house, as appears to have happened in this case, then that's a misdemeanor that would justify a warrantless search of the house. That's pretty dramatic.
Absolutely. I think Justice Gorsuch said at oral argument that we're living in a period where everything is criminalized, which may have been a bit of hyperbole on his part, but you're absolutely right. If the misdemeanor is enough to get police in your doors, it certainly opens up a slippery slope argument on that side. For sure.
Yeah, it does. And so the other working sort of moving piece in this case that I think is really interesting is this idea of hot pursuit, right? Some courts have treated hot pursuit as literally a hot pursuit, where an officer is in true hot pursuit of a suspect, but other courts have treated it much less loosely and said, look, anytime an officer is following a suspect, that's going to fall within the hot pursuit rule. And again, what that means is in a case like this, an officer, it's kind of hard to say that Weichert was in hot pursuit of Lange here. He followed him into his driveway. He could just as easily have knocked on his door, for example. But yet some courts have treated this as a hot pursuit. And so that too, I think, is a kind of open question in the case. And, what does hot pursuit mean? If we're going to continue with the categorical exception for hot pursuit of felonies, are we going to narrow the definition of hot pursuit? And that issue came up in a couple of questions as well.
Yeah, and I think also the attorney for the lower court's decision, which we'll loop back to, I want to make sure we talk about the attorneys that were arguing and why there were four. She argued, we need to give officers some of these freedoms. Exigent circumstance exception exists for a very valid reason, and the hot pursuit exception to the exigent circumstances case by case exception also exists for a very specific reason. And you don't want an officer stopping in the middle of an actual hot pursuit to sort of weigh all of, how is this going to be looked at by a reviewing court? But yeah, I think that this was one that I think the justices were really struggling with. And as I was preparing for our chat today, I was really struggling with, and I think it'll be really interesting to see where the court plays out. So Steve, can you talk to us a little bit about why there were four attorneys and sort of what happened in the last, before this got to the Supreme Court, and this idea of having an amicus argue before the court?
Sure. A little unusual, right? We don't see this every day. And I think the fact that there were four attorneys, and of course, the fact that we're still doing oral arguments by phone, both contributed to this kind of uncertainty, right? I mean, I went back and read and listened to the transcripts and read as much review of the oral argument as is out there. And I still kind of scratching my head, wondering what the court's going to do with this one. There were four attorneys in the case. So one was representing Lange, right? And that is typical, that's customary. Another was representing the state of California, but not in defense of the lower court's ruling, because as it turns out, California declined to defend the lower court's ruling, which is a little unusual. So the lower court ruled against Lange, but then at that point, the state said, well, we're not going to defend that ruling. We think they got it wrong on the categorical application of the hot pursuit rule to misdemeanors. We don't think it should go that far. We think it should go to felonies, but not to misdemeanors. And that's the argument that California pitched. Now, with California not arguing in defense of the lower court's ruling, the Supreme Court had to appoint an amicus, a friend of the court, to argue on behalf of what would be the state's position in defense of the lower court's ruling. And the amicus did that quite capably and argued, sort of full throttle that there ought to be a hot pursuit exception that applies to both felonies and misdemeanors, and that we ought to interpret this idea of hot pursuit pretty loosely. So that's three of the four. The fourth of the four was the United States government itself coming in as amicus, another friend of the court, which we see happen in high-profile cases from time to time. And the United States government had a subtly different position than the amicus had. What the government said was, we don't think that there ought to be an automatic warrant exception for hot pursuit of misdemeanors, but we think there ought to be a presumption in favor of a non-warrant requirement in the case of hot pursuit of misdemeanors. So all this meant that we had a very long argument this week and a very nuanced argument in some ways around the Fourth Amendment, and also a very confusing argument in terms of predicting the result.
Indeed. I hope the decisions and the opinions aren't quite as confused and we get a bit more clarity coming out of this.
Hey, Kathy, let me ask you. So
Yeah.
I've kind of been toying with this in my mind. I mean, this seems like a case, just given the facts, that could resonate with a lot of people. One of the things that Lange raises in the case too is how a rule might apply to defendants of color who, for a variety of structural racism reasons, are more often subject to misdemeanor investigations than white people, for example, and that it may have a disparate racial effect if the court were to adopt, say, the amicus's rule here. Given all that, I'm just wondering it seems like a really good case to use in the classroom. Do you have thoughts on that?
Yeah, I think it absolutely is. I think you're spot on, and I appreciate you bringing up that facet of the case. It actually, to me, sort of seems to be on a trend line with a case we discussed back in October, Torres versus Madrid, which was another policing case involving use of deadly force or potentially deadly force by the police that got a lot more play than it was supposed to in the spring when it was originally going to be argued, in light of the discussions about police force over the summer, and the Black Lives Movement protests and all that. And I think these are all kind of tied together. And for me, it's really showing, I think, how some of what we used to talk about with educators and about how using these Fourth Amendment cases or these policing cases were sort of not cut and dry, but they were, they were fun cases, for lack of a better term. And I use that not in the sense of anyone's having fun who's involved in them, but they were great cases to involve students with because the students have seen these things play out on TV. And I think there's a greater recognition now that the way we address these cases with students has to come from a place of compassion. It has to come from a place of meeting the students in their lived civics environment. What are they experiencing in their communities? What are their family members experiencing in their communities? And I think this case in Torres versus Madrid is another example, gives us a chance to talk to students about how they're experiencing these in these issues in their environments, and then places it in the larger context of the criminal justice system, the Constitution, the Supreme Court. And it really gives you a way to allow students and the general public to see how what maybe might be this lofty idea that's getting argued at the Supreme Court really can impact their day-to-day life or their family's day-to-day life, and really allows students to draw those nuances out for themselves. What about you, Steve? What do you think?
Yeah, no, I like that a lot. And I think, I think the facts of the case could resonate with a variety of different student groups. And I really like how you frame that, talk about their lived civic experiences within the larger context of so many important issues that we're talking about these days. Structural issues with regard to policing and especially racial minority communities.
Yeah. Well, we'll keep a close eye on this one and hopefully come back together once we get a decision with hopefully some clarity. And Steve, I look forward to looking at some cases later in March with you and maybe talking about the impact of the change in administration at the court as well.
You bet. Thanks so much for having me, Kathy. It's been a good discussion.
Bye-bye.